Morning.
Morning, Mike.
Morning, Mike.
Good morning.
Morning, everyone.
Morning, Kyle.
Morning, Kyle. Kirsten, let me know when we're good to go.
You're all set.
Okay. And I will go ahead and call the December 12th, 2023 meeting of the Medical Records Requests and Records Fee Working Group and ask my co-chair if she has any remarks.
Good morning, everyone. I appreciate that we had a couple proposals sent to us and to discuss today. And I believe we're going to try to get our hands around the discussion of the non-worker stuff matters today, so we can move on to the workers' comp matters for our next meeting.
All right, thank you. First item then is approval of the minutes from the November 28th meeting. If I could have a motion.
So moved.
Thank you, Mike. Second, Chris. Any discussion? Seeing none, all in favor?
Aye.
Aye.
Opposed? Motion carries. All right, we'll next move on to continuing our discussion on the non-workers' comp medical records requests. Kyle, we just got the proposal from your groups. Do you want to summarize it, or do you want me to have somebody else summarize it?
I can summarize it. That's fine.
Okay.
Thank you.
Yeah, go right ahead, Kyle.
Okay. Just so everyone knows, I'm going to flip over to my other screen here so I can see the document. Essentially, what our industry was trying to accomplish here is to modernize the medical record fee statute to acknowledge that there is a ubiquity of electronic records, but that they come from different sources and that there's still a great amount of manual labor involved in the production of these medical records, and that privacy is at the forefront of any disclosure. And so we looked at the existing statute and tried to work within its confines so as not to do a complete rewrite. We also tried to address the issue of turnaround time, which was a concern during legislative session and has also been mentioned by this work group in previous meetings. So with that, I think I'll just jump right into the actual fee provisions that we proposed. We proposed, because the fees were established in today's statute back in, I believe it was 1993. And I think in the previous meeting, I said if you adjusted these by CPI using the U.S. Bureau of Labor and Statistics CPI calculator, that would be about $1.40 a page now. I am not coming in, and our industry is not coming in and asking for that kind of an increase. But we are asking for an increase on the paper records. Now, I understand there's concern that we've heard for years, not just in Connecticut, but across the country, that, you know, these medical records should be easier to transfer, they should be cheaper. And what I would like to do, and what the industry would like to do, is address what I refer to as like the runaway invoices, where I have routinely seen like $1,000, $5,000 invoices brought into committee meetings, and people say that they've had to pay this for medical records. And so what our industry is asking is that we get a fair fee for all records, and we prohibit those runaway invoices. So we would propose that the paper rate go from the current 65 cents a page to 90 cents a page. Acknowledging some increase in costs of everything these days, including the cost of labor, the cost of technology, the cost of doing business, the cost of supplies. Everything has gone up. And so we would request a paper increase from the 65 cents to 90 cents a page. And we would not propose any cap on the paper records. This would be partly because we want an incentive for people to request electronic. And you can infer from that statement that we will propose a cap on an electronic copy of a record. We would propose then that we have the 90 cents a page for paper, and then we would do a reduction for an electronic page. We would still use the per page system, but we would bill it at 60 cents a page, which is 5 cents less than what is today, but it's 2/3 of what the paper rate would be. So we would have a 90-cent paper rate per page and 60 cents per page for an electronic copy. In addition, we are proposing a $300 maximum amount on an electronic record. So if you request an electronic copy of a record, an electronic copy is delivered, then your invoice would be capped at $300, regardless of how much the actual work was involved and how many pages were involved, et cetera. In addition, I had discussed before the work that's involved in validating the requests, identifying the requests, going through the request documents, understanding all of the paperwork and documents that are submitted, identifying the proper medical record number, then going into the various EHRs, which inevitably exist at most sites, and locating the actual records before you begin the page-by-page review. And for that, we would propose a fee that's consistent with the national average for states with these base fees or search and handling fees. We would propose that a fee of $25 be imposed for a paper copy and an electronic copy. So your total fee then would be the $25 search and handling fee plus the per page fee, whether you chose to receive a paper copy or an electronic copy. And then you would be capped at $300 for an electronic copy. Now, we also propose some radiology fees. We're seeing a lot more radiology requests. This is an area that we are venturing into to assist our providers with their release of information. And so we've also proposed a $30 flat fee for furnishing an electronic copy of a radiology image. So if you have a group of MRIs, X-rays, if we can burn those onto one CD or if we can send them electronically through a portal, it would be a flat fee of $30. If we have to burn them onto an actual film, then it would be $10 per printed film for that service. Now, the fees that I've mentioned are in addition to any postage or taxes that are required by the state of Connecticut. So those would be additional costs. So you potentially could go over the $300 if you asked for a CD to be mailed to you. Then we would have the mailing cost, which would be, fairly nominal. You're talking less than $2 to mail something within the state of Connecticut if it's a CD. Then we're looking at the turnaround time provisions. I understand that's a concern, and we're here to try and turn these records around quickly to the requesters. I can say affirmatively that we do our best to do that. We are not in the business of holding back records. We're in the business of producing records to those who are authorized under law to get them and authorized by the patient to get them. And so with that in mind, we propose a 30-day turnaround time where we have to respond to the request. And the reason I phrase it as respond to the request or provide a written response to the request is because, as I explained before, there are many times when we don't have enough information in the file. Maybe the patient authorization is missing a certain element. Maybe we need proof of an executor who can actually sign the authorization. We don't have the estate documentation yet. So to actually get the record in the requester's hands within 30 days may not always be appropriate, because we can't violate existing laws in order to get you the record in your hands. However, I do think it's reasonable to put an obligation that we would respond in some form or fashion in writing to the requester within that 30-day time period and say, we need this additional documentation so that it's not hanging out there. Now, the expectation on our end is that most requests will have what we need, and we should be able to turn these around within 30 days. I would also propose that the clock actually start ticking when we actually get that request. but I understand that there's some complications with doing that. So we've proposed that the date of the receipt of such request shall be deemed to be 3 days after the date the envelope is postmarked. If it's sent electronically, then we propose that the delivery date be assumed to be 2 days after it's sent by either facsimile or electronic mail. If the request is not returned or there's not a written response within 30 days, we would propose a 50% reduction of whatever the original invoice was. So if the original invoice, let's say that it was a 1,000-page electronic record and it was capped at $300, if we miss that 30-day deadline, then it would be 50% of that, and it would go down to $150 of the original invoice. We also want to point out that we added a CPI adjuster to the law here as well. There are currently, I believe it's 15 states that have CPI adjusters in their law. This law sat on the books since 1993. We're talking 30 years there. So we would like to, and I believe that this is something we can definitely talk about. It doesn't have to be an annual adjustment, but I believe that we should have some kind of a CPI adjuster so that the legislature doesn't have to continuously come back and review this issue. We put the obligation on the Connecticut Department of Health to actually perform that calculation using the U.S. Bureau of Labor and Statistics CPI calculator, and then publishing it on their website so that any requesters in the state of Connecticut or outside of Connecticut who are requesting Connecticut records would be able to find what the current rates are. And lastly, I'd like to point out that we are addressing both statutes, which I don't believe was an oversight. I think it was just for simplification, but we're addressing section 19A, 490B, and 20-7C. So we're covering all medical providers here, the hospitals, as well as the individual practice groups and doctors. So in a nutshell, that is our proposal.
Okay, let's talk about the $25 search fee right off the bat.
Sure.
What, because that doesn't currently exist. So what's the basis for that?
The basis for that is really all that initial validation work. Whenever we get a request that comes in from a third party, we've got a lot of documentation that comes along with that. We'll have like a patient signed authorization that we've got to make sure is HIPAA compliant, has all of the 9 elements as well as the required statements that are on there. That information can also be handwritten. So it could be a matter of like, as far as the scope of what records are allowed to be released, it may have actual handwritten dates that we would have to interpret as to what dates the records can be disclosed. We have additional documentation such as subpoenas could come in. The subpoenas may have court orders with them. We may have estate documentation. We have personal representative documentation. We may have power of attorney documentation. There's all kinds of documentation that comes along with these requests. They're not always as simple as just an authorization. I mean, we've got request letters, and many of the attorney requesters, quite frankly, will have instructions in their request letter that's not in the authorization. And they'll say things like, I do not want to have this delivered through the portal. I want it done by a CD. And I would like you to tell me, call my office first if it's going to be over $50 because I would like to approve it first. So you've got all these little complications that slow down the process. And we've got to weed through all that and make sure that we do what is being requested of us as well as fulfill the request. And that's another reason why we think that the turnaround time, you know, if we contact your office about a request that says, please contact me if the invoice is over $50, and we don't reach anyone and have to leave a voicemail, now we're playing phone tag. And so that slows the process down as well. And so at that point, it would be incumbent upon us to send out some kind of a written response to you all saying, we've tried to contact your office. You asked us to contact you if the invoice was over $50. Please contact us. We've processed it and it's over that. So that would qualify as the written response. So it's all that initial validation work. And then, like we also discussed, many of these hospitals have multiple EHR systems. So you'll have to go into multiple EHRs, and I've seen some as high as having 7 or 8 different EHRs. And so you'll have to go into each EHR and look for the requested records, because if you find a record in the first one and you stop your search there thinking you've resolved the issue, you may have records for that patient in the other EHRs that you didn't check. So you've got to go through even if there isn't a record in each of those. So it's all that initial validation work and the initial search and retrieval part, including the medical record number, which I think I described before. The medical record number is in separate software from the EHR. So you've got to actually retrieve the medical record number for that patient and then use that when you go into the EHR to look for the patient's records.
So let's say I've got a client in a car accident who's treating on a consistent basis with an orthopedic doctor, and the orthopedic doctor uses a third-party medical provider for purposes of the records. So my client is seeing this orthopedic, let's say, every 6 weeks. So every 6 weeks, when I request an update of the record, I'm first going to get hit with the $25 search fee?
Yes, that would be because each request that comes in will have to be evaluated. Now, I think what you're suggesting is, can't you have just one initial search and validation, and then if you're sending the same authorization, you're just updating the request for narrower request dates? Is that correct?
Yeah.
And I've spoken with our IT team and our operations team about that approach, and we currently aren't set up to be able to handle or take that fee off of, because when we respond, that is that request in our system. We don't leave a request open. We close it when the requested records are sent out the door or a correspondence letter is sent out the door. So we would have to figure out a way technologically to do that. I'm not saying it's not possible. I'm saying, like, if we were to do, okay, so I guess what I'm saying is, if we were to come up with some way to do that, we wouldn't be able to say, okay, this bill is effective upon passage, because our IT team's gonna have to develop that. I mean, otherwise we're gonna have to do everything on hand, and you're not gonna get electronic records, because we're not gonna be able to. Our billing system isn't set up that way now. It would take some development time. Does that make sense?
Yeah, it does. Just going on to on the workers' compensation side, we have a generally accepted medical requests HIPAA compliant form that we submit. If the state was to develop one that would apply to all situations, and all of the companies are in agreement that this is the proper form, wouldn't that negate the need to look at the form every time we send it in? If it's a statutorily accepted HIPAA compliant form, and that's what we're sending in, rather than something that we make up ourselves. What work would need to be done to validate a resubmission of the same form if it's a form that everybody agrees is legally sufficient?
So the problem with that is that, and I'm not advocating we shouldn't have a form document. I think that would be great. But within the form document, there are certain terms that can be variables, like how long is the form good for? And the patient gets to fill that in. They can say 1 year, they can say until the end of my litigation, they can say for 30 days, they can say until I die, right? They can put whatever limitations they want in there. So that's not going to be form language. As far as what provider is able to release the records under this authorization, under HIPAA, every authorization has to state the provider by either name or association. So that's going to be a variable. So we'll still have to read that, right? We can't just get an authorization in a package and say, hey, we have an authorization, we're good to go. We have to make sure that it's for those providers in that practice or for that facility. Then you have the notice provisions. Now, regarding the form language, I agree that if you have a form, then everyone uses the form, then it should speed up the process, but you still got to validate that the form matches what was sent to you. You can't just assume that what you got matches the form, because it may not. And I'm not splitting hairs here about, like, did they change a to a the? That's not what I mean. I want to make sure that all of the consents and the notices that are required under HIPAA, that I'm assuming you would also require under Connecticut law, are properly worded and advising the patient of their privacy rights in that form. So we do go through and look at that form and make sure, yes, this matches the state form. Is that faster if we have a form document as opposed to everyone sending in their own? Absolutely it is. That would streamline things. And I would advocate that we do consider some kind of a form. But that doesn't mean just because you have a form in your statute that you can neglect comparing to make sure that this thing you received in the mail matches what's in the law. You still have to confirm that those two match.
Okay. When a medical provider contracts with you to do the records, how are those contracts structured? Is it a flat fee that you're charging the provider to do their records, or do you charge the providers, a per patient or per record fee? How, for lack of a better word, how do you guys make money when you contract with a provider to do their records?
Without getting into anything like proprietary or anti-competitive, I would say that our industry, generally speaking, and I say this just from experience with the industry, is that for the release of information services, we typically are not paid by the provider. Our contracts are worded in a way that what we do is they assign the rights to collect the fees under the statutes to us. So they say you will perform the release of information services, and in exchange, we will assign any statutory right to a fee to you to collect. So the fees that we get for the services are typically paid by these various third-party requests. And like I said before, it's not always attorney requests. It could be from insurance requests, it could be government requests, it could be patient requests, and then in our contracts, we may have a hospital customer that says, for my particular patient, if they want their own record, if they come in here and say, I want you to give me my record so I can give it to my doctor, they may say, we want you to do those requests for free. Now, we also have various software offerings. So we may charge the provider something because we'll charge them for the software that we offer. But for the actual performance of the release of information services that we're discussing here today, we typically do not charge the provider for that service. That is charged to the third parties, and then they assign the right to collect any statutory fees to us.
Okay. All right, Rep. Conley.
I have some, I appreciate you sending a proposal. I have some serious concerns with this proposal. And I'll just note a couple of them. The $25 fee to start with, I think is not taking into account the practicalities of getting medical records. I think there is an assumption that each request is complex. And I think that the proposal to put that in each request, making everything complex, is ignoring the reality that many proposals are very simple. I would say a common proposal I'd say is an MRI report, not a film, a report which is a page and a half long. And with the HIPAA compliant request, that currently costs $1.30 for a page and a half. And with this proposal, that would bring that up to $26.80 for that same page and a half. Commonly, folks treat for car accidents or slip and falls every 4 to 6 weeks. And again, they probably have a 2 or 3 page report from their primary doctor. So that would be a $2 report up to a $27 report. That is a huge increase. That's far more than the statutory or any adjusted rate. And with the proper HIPAA compliant request, and I'll note 2 of the main hospitals that I often request records for have their own HIPAA compliant forms that the clients sign and that are sent in. Either the client's providing through their attorney or the client's providing it through discovery request to opposing counsel to get those documents. So if the hospital is providing their own HIPAA compliant form and that is being emailed in for the hospital's request, I understand some of the hospitals may use third-party companies, but a fact to increase the cost of that by that dramatic, I don't think is something that this working group should be supporting. As far as the CPI adjusted, I don't think now is the time to add that into the statute. Again, we talked about, we do need to look at the statute from 1993, but a, 200% increase for records plus an adjuster, I don't think is appropriate at this time. I think that's putting a lot of things against the wall. And I do have an issue with stating that all facilities are using third-party companies, which is not the current status. I understand some are using third-party companies and some are finding great need in a savings to the hospital or an increase. but many physicians, many locations, many MRI areas are not using third-party companies. So to have these rates increase on people that are not using them by the needs of what's been proposed by this third-party company, I think is inappropriate. Again, I emailed a request to a doctor's office who is part of Yale, but does their own records. And they emailed me the request the same day. Again, smaller office with a appropriate fee for that email. I'm not saying every doctor's office can do that, but I wouldn't want, if that doctor's office can do that, by changing the law, you're forcing them to charge $26.80 for that same record that they emailed me in like 20 minutes. So I think while some people have their smaller offices may have it better or a better system or a system that works for them, I think assuming that everyone would use the big system with these big rates and these big needs is probably inappropriate to our current status. Some people do need these, and I do think 1,000-page request is very different than the 1.5-page request. And I think this proposal ignores that aspect. As far as the turnaround time, I understand the snail mail in the 3 days, but a lot of these facilities are having documents be emailed or faxed. The fact that the email faxed receipt date is not the receipt date. Again, it's not the requester's decision to use a third-party vendor. So to tack that time on to the requester for everyone, I don't think is fair to add more time. I could see the mailing rate. If you're going to snail mail it, that would be a few days for it to get to its location. And I would say 30 days to get the response, because I do see the SIOX letters, the 1-page standard letter. We received your response. Those come about 5 or 6 days after the request. I do not see a reason to expand that to 30 days in any way. I get that 1 page that says we've received your request. I do not understand why that would be expanded to 30 days. I understand that if there's communication, if there's a need for, a probate court certificate expired and someone needs to get an updated probate certificate, of course, the updated certificate would need the time, and the time should not continue to run if there's an issue with a probate certificate expiring or if there is a request for a different form. But I want to be clear that Yale and UConn have their own forms. And if you're using the forms of the provider that's HIPAA compliant, I do not see the reason to expand the time.
All right, thank you. Mike?
Thank you, Chairman. I didn't have a chance to fully digest the proposal, so I apologize that I might not have fully informed responses, but I did want to mention a few things. And I submitted a revised proposal, and I would respectfully ask for an opportunity to comment on that, but some of these things overlap. So one of the issues that I think is problematic is that the proposal that was submitted by Kyle, I think, ignores the fact that patient requests and lawyer requests or other authorized representative requests, unless they're representatives that have authority to make healthcare decisions, that those requests are currently treated, as Kyle mentioned in one of our prior meetings, differently under federal law. And that's been part of the problem that we're trying to solve here. And so some of the things that Kyle has proposed in this proposal, as I understand it, violate federal law. So as an example, HHS guidance makes it clear that search fees are not allowable for patient requests. Per page fees for electronic records are not allowable for patient requests. So when I revised my proposal, I took that into consideration, realizing that we don't want to have anything that conflicts with federal law. And so I also wanted to allow an opportunity to address some of Kyle's thoughts and issues by separating out those two categories of requests: patient requests on one hand and attorneys and other authorized representatives on the other. The other thing that I found to be somewhat surprising, if the goal here is to try to come up with a reasoned proposal that's going to work for all the interest groups, was that the amounts that were suggested for the cap on the electronic record amount, the $300, is way, way, way far above the amount that's been the cap in any other state that's considered the issue, and is actually 42 times the amount allowed under federal law for an electronic copy for a patient request. So I found that charge to be quite substantial. The other thing that I was, a little surprised was the uptick in the per page fee. There are a lot of reasons why the process has been streamlined and is actually easier. And so when I took a look at all the other states that have something on the books in terms of a per page fee, and by that I'm talking about hard copy, and not only all the other states, but even in the list that Kyle submitted, the average per page fees for a hard copy are below the current amount that's in the statute of 65 cents a page. And the only thing that I thought merited some type of consideration in terms of hard copy was if you're asking for a color copy. And we all know that the toner costs a little bit more, and so that might be a consideration. But to bump up the per page fee for a hard copy seemed to be inconsistent with the average rate for hard copies across the country. When I say average, sometimes it's a little difficult to calculate the average because some states have a tiered system, as we mentioned in other meetings. And so the first so-and-so pages are X, the next so-and-so pages are X. So what I tried to do was I tried to take all of those tiers, if it was one of those states, average that to a per page, and then use that as that state's per page fee for a hard copy. And then I averaged them all out. But none of them come out to the amount that's been proposed here in terms of an average. There were a couple of things that I thought were helpful. One of the things that Jennifer, I don't see that she's on, but one of the things that Jennifer had mentioned was the wording on who can charge the amount. Is it the healthcare provider? And then I think in my proposal I said, or someone else who's in possession and control, and Jennifer wondered whether or not that was the best wording, and Kyle substituted the word business associate. I thought that was a reasonable suggestion. It's not defined what's meant by business associate in the proposal that Kyle submitted, but we could take care of that. And we can probably borrow some of the interpretation from federal law where business associate is further defined and informed. I hear and I appreciate the attempt to try to deal with the timing of the requests. I also share Representative Conley's concerns about how do we deal with that. It may be something that can be figured out, the timing of the requests and any delays associated with who gets it when. But the thing that I found a little shocking in our prior meetings when Kyle and I were discussing the issue was that it doesn't appear as if the healthcare providers and the business associates, if you will, are doing anything to track when the actual request is received by the healthcare provider versus when it's actually received by the business associate. And that seems to be more of an issue, as I see it, between the healthcare provider and the business associate, we shouldn't, as requesters, whether they be patient or authorized representatives, necessarily have to deal with, but a way of tracking that time, if it's something that everyone feels is necessary, I think we can probably come to some reasoned solution for that. I agree that both statutes need to be addressed. That wasn't intentional by any stretch. It was, the other statute was designed, I think, mostly to deal with tissue slides. If you read the wording of it, I mean, it does apply to hospitals and facilities, but there was a special provision in there about tissue slides, and some of the wording in Kyle's proposal about that, doesn't make logical sense, because you wouldn't charge $10 for a copy of a tissue slide. You actually need the tissue slide. How do you deal with charges for imaging studies? That's something that probably needs some further discussion. But in our experience, much of this imaging these days is easily transferred into, onto an electronic format of some kind and then transmitted. The only difficulty we've had has really been sometimes those require special programs to open up in order to be able to access them. And so we then either have to download them or sometimes purchase them so that we can actually read those. So the readable format of those is something that has to be grappled with sometimes. Those are really some thoughts that I had in the few minutes I had to read this morning. But I appreciate the opportunity to comment on it. And I would like the opportunity to discuss, perhaps not this moment, but my revised proposal as well. Thank you.
Okay. Thank you, Mike. Rick?
I just have two questions. I'd like to clarify something. As I understand it, Kyle, that you charge Yale New Haven Hospital based on the anticipated volume of service. Is that correct?
I don't have the particulars of any Yale New Haven Hospital contract in front of me right now. I can't answer what we do or don't charge. I was answering as a general business model, how the industry approaches release of information.
Yeah, I'm asking you a very specific question.
I know, and I can't answer Yale New Haven questions.
It's a general question. You charge hospitals based on essentially their size and volume of services that you have to give them, and volume of services is based on the anticipated amount of copies that you're giving in response to requests. Isn't that a general correct statement?
You said that we charge the hospitals. Can you repeat that for me?
Yes, I'd be delighted to repeat it. You charge hospitals based on the anticipated volume and size of services that you render them. For instance, you have Yale New Haven Hospital, which may be 600 beds, could be 1,000 or 1,200, depending on other hospitals. And then you've got Griffin Hospital. I don't know what Griffin has, 100, 150. So obviously the amount of records for Griffin is different than Yale New Haven. So you charge a different service fee based on the anticipated volume of services, which means furnishing records to hospitals. Isn't that correct?
As I stated earlier, generally the business model is that we don't charge the hospitals for our release of information service. Our contracts are structured so that we bill the third parties who are requesting records, and they assign the ability to collect those statutory fees to us.
Well, let me ask you this question. What is the basis? You don't give your services to the hospital without cost. What is the basis that you charge hospitals? The basis that you charge hospitals?
I just explained we typically don't charge for release of information services. It's an assignment of the ability to collect a fee.
Well, what do you charge? What do you charge hospitals for? In other words, hospitals, is that correct? You You get money from hospitals, isn't that correct?
In some cases, no, we get none.
You get, well, for Yale New Haven Hospital, you get a substantial fee, isn't that true?
I have no idea. I don't have that contract in front of me. Is this a deposition?
No, what it is you are asking, I think your requests are excessive. So what I'm trying to do is determine whether what your other income is from providing these services directly to the hospitals. In other words, you don't deny that you get a fee from Yale New Haven and all of Yale New Haven hospitals, correct? You charge them. And I'm asking you, what is the basis of your charge?
I think Cal's frozen, but
Yeah.
if I could chime in really quick,
Wait, I didn't hear a response to that.
He's frozen, so he couldn't respond.
I do have one other quick question, if I might, Chairman.
Yeah, Liz, do you want to take a stab at answering that question?
yes. So I was just going to concur with what Kyle had said. For AHIOS, the majority of our members do structure our contracts in that fashion where we don't necessarily charge a fee to the hospital, but essentially what we've recouped from three parties according to statutory guidelines, that does cover the cost and allow us to provide that service to the hospital or clinic.
I apologize. My computer glitched there. That was not intentional. I realized the timing was terrible, but yes, I agree with what Liz said. We typically do not collect a fee from the hospitals for the release of information services. As I stated, we may offer additional services to them, like computer software for auditing. We have a program called Audit Pro, and we will license the software to them and collect a fee for that. We typically don't collect a fee for the release of information services, but I can't answer a direct question about Yale New Haven. I don't have the contract here to review and tell you.
Well, you would be able to provide that information to us, correct?
It may be proprietary. I don't know that I could disclose what we're charging. I wouldn't want Liz's companies or any of the other companies that AHIOS represents to know what we're charging or not charging.
I'm not asking you specifically what the amount is. I'm asking you what the ramifications in total for all your services that you provide that you get paid for. Not the amount, but what services you get paid for.
And I believe I've answered that. For release of information services, the providers don't pay us. We recoup the fees that are allowed under state law and federal law.
I'm sorry, it's difficult for me, okay? It's difficult for me to accept that you're doing this without payment for what you're doing, because at $6.50 a page, okay, you're not getting compensated for what you complain you're doing. I have one other question. I have sent to the committee, I don't know whether it's been published, a couple of requests that we've made that have taken 3 months, 20 phone calls, 15 phone calls, very expensive for us, and I've documented that. Do you keep any record of the times that you take 2 months or 3 months to return a request for records? Do you keep any record of that?
For each request for medical records, we have a history log of any correspondence that we send out, any emails and phone calls that we would have on that file. So we do have a request log that has contact with the customers and any actions we've taken. So the answer to that is yes.
Well, no, that's not my question. My question is, when you take 60 days or 90 days to supply records, do you keep any record specifically of that so you can respond and reduce the 60 and 90-day returns? In other words, do you monitor poor service, especially?
Well, of course, we want to increase performance and efficiencies. As I stated earlier, it doesn't do us any good to take a long time to respond to a record request, because we make our money from responding to requests that are valid and legal and authorized. So we want to get those out the door. So yes, we want to increase turnaround times. We want to increase our performance and efficiencies.
That's not my question. My question is, when you have a 60-day record with me of delay and 90 days, you keep a separate record to make sure that you reform those terrible delays of 60 and 90 days to get records. You
I think I've answered this. I don't know how to answer you. I mean, no, I don't know about Rick Silver's request. I don't have that information in front of me. We're talking about a legislative proposal generally here. I didn't realize that I'd have to have information about specific requests you made on one patient.
It's not me. In other words, I'm talking generally. In other words,
you just said your request that was 60 days past due. You wanted to know.
All right, hang on a second. Let me ask this in a different way, which I think gets to the answer. Do each of the companies track how long it takes them to get a record out? And again, my assumption is that you have people working for you, and each person perhaps has certain accounts that they work on. So let's say Mary is the person who works for you and she handles all the Yale records. Do you keep track of how long it takes Mary to get record requests out?
There isn't a tracker on an individual because people are assigned different tasks.
Okay.
Think of our system as a production line. When we get in a stack of requests in the mail that day, someone sits there and actually goes through each of the requests. They don't say, I have John Doe's request. Now I'm going to stick with John Doe's request until it is received. They pass it through the production line. So we have somebody, I mean, that's like any good production line, you would have people that are really good at their task of validating authorizations, and that's what they do. They don't go into the EHR. So then they pass it along to somebody else. Now, there are people along the path that are familiar with all those other steps because they may have received promotions or gotten changed of positions, or they're cross-trained to fill in for vacations. But this is a production line. We take a stack of requests when they come in, we review them, we enter them into our health source system, and then they're passed along. And then the next person goes in, and then they find medical record numbers for each of the patients, and we'll write them down on the request itself and in our health source system. And then it's passed along. And then it goes to somebody else who will actually go into the EHR. And we have several people who are going into EHRs on a regular basis. So this is a production line. It's not like we can't sit there and say, okay, Mary opened this request letter for John Doe, start the stopwatch, and then stop the stopwatch when the record goes out the door, because that's not how we process records. That's very inefficient, because then you're only going to take those requests as they come in. And as we discussed before, there are certain priority requests that have to be dealt with first, like for continuing care, for authorization for treatment, things of that nature. So that's where they get filtered through when we enter them into our system. They're prioritized so that the ones that we have to get out the door, that the client has prioritized or that law has prioritized, those get addressed first. Like subpoenas, they have response dates that we've got to comply with, or you could be in violation of a subpoena. So it's not a stopwatch process where Mary can be evaluated on how long it took her to get a record out the door. It's company performance. Now we can judge like facility performance, how our employees are performing at a particular facility.
It's more like a holistic team, I think is what Kyle is saying. So from, across, a particular, facility or an organization, obviously we want to make sure that we're efficient and we're improving on our, performance. So we would be able to look at that, at that level.
Okay. In your proposal, there's the, I'll call it a fine, but it isn't really a fine, just a reduction in fee if the record takes more than a certain amount of time. Now, let's assume that that was the law at the moment. I would think you would probably keep track of employees who are not getting records out within that time, and thus costing you half of the potential fee that you're entitled to. Would that be a fairer assessment?
I don't think so, because it would be judged on the facility. Again, it's a production line and we do that for efficiency. So it would be the entire system. It would be like that facility is lagging in their responses. And again, I want to emphasize in our proposal, it wasn't simply that the record gets out, but that a correspondence goes out, some kind of written response to the request. But yes, we would obviously track performance. We track it to this day. I mean, but we don't track it on like how long does it take one record to get out the door from one person producing it, because that's not the way it's done.
Okay. Rick, anything else?
No, that's fine. Thank you very much.
Okay. Carl?
Yes, hi, good morning, everyone. Just a reminder, I'm Carl Schissel from the Connecticut Hospital Association. You know, high reliability organizations are known to defer to expertise, and Jennifer Cox of Cox and Oswecki has been our expert, you know, in this area. She sends her regrets that she can't be with us today. Interestingly enough, what is she doing? There's a 6-hour program on HIPAA privacy, addressing not only the privacy rule, but the security rule and the breach rule. And she's talking about how to keep current in order to remain compliant. So when I ran into her this morning, when faced with a 6-hour program versus a 2-hour meeting with a nice working group, she wishes she could be here with us today. But frankly, I'm glad she's doing what she's doing, because she's trying to make sure that healthcare providers don't run afoul of the various federal rules that apply to all of us who are involved in managing healthcare information. So we appreciate at CHA the drafts that are circulating around. And obviously, we have not had an opportunity to fully digest or socialize with our other experts some of the concepts, you know, that are represented in those proposals. And we're very appreciative of the working group and the fact that this conversation is happening. But, you know, from my perspective, given the time of year and where we are in the process and what we're looking at, we did think it was important, while we're not necessarily going to submit today comments on the various draft proposals, we thought it would be appropriate at this juncture to articulate some core principles that are guiding us in this work. And as you might expect, it focuses exclusively on patient rights. And essentially, I have 4 thoughts I wanted to share with the group, and I'll do so as succinctly as possible, if you'll allow me the indulgence of doing so. And in fact, 2 of the principles have already been discussed in part at this meeting. Core principle number 1 is that Connecticut law should support patient rights as our North Star. This includes the reality that HIPAA privacy rules already insist that providers act as the gatekeepers for patients' medical records privacy rights. This reality and the need to comply with the federal requirements, you know, adds time to processing requests, whether you're doing it yourself or whether you're hiring, you know, a firm such as some of those represented here. It is meant to be a deliberative process. And as Kyle mentioned earlier, even with the presence of a quote unquote HIPAA compliant form, which of course, you know, is based on an assessment made by someone who claims to know the rules of HIPAA, in each instance, the process provides that a provider simply must verify and validate that all the necessary forms and paperwork are documented, and if an authorization is needed, that it's valid and complete, and that all the other privacy laws, in addition to HIPAA, have in fact been met. The provider, as the HIPAA mandated gatekeeper, simply doesn't have the luxury of assuming that the requester is legitimate or has completed all the necessary steps. So that's sort of principle number 1. Principle number 2, you know, Attorney D'Amico actually made reference to this. Connecticut laws should be designed as consistent with HIPAA obligations and should first and foremost promote patient privacy. And as mentioned earlier, HIPAA plainly separates the right of a patient or individual to access their own records, that's 45 CFR section 164-524, from the ability of a third party, including patients' lawyers, to access records with an authorization. That's under 45 CFR 164.508. Simply stated, Connecticut law cannot blur that line, and doing so risks trampling on patient privacy rights. So we have to be mindful of what the current requirements are under federal law. Third, if Connecticut elects to expedite all records, this is kind of an axiom. If you expedite all records, then no records are truly, expedited. And frankly, from the patient care perspective, if we're going to be expediting records requests, those expedited requests, in my opinion, should be reserved for medical purposes pertaining to treatment and or payment and prior authorization uses. If it promotes an expeditious treatment of the patient, then I think it's worth talking about. I don't think legal uses should be prioritized over medical purposes. And I did want to mention, I'm not sure we've talked about this. I don't think I was at the first meeting. Connecticut law now requires an expedited processing of record requests. Public Act 23-97, Section 43, it was Senate Bill 9, for those of you who recall, is effective on January 1st, 2024. We don't know yet what the impact of this new law will be, so it's kind of premature to try to prioritize other requests until we know what the impact of Public Act 2397 is on the world. And maybe some of you who are closer to that new Connecticut law can talk about what your expectations are in terms of the implementation of the new law. But it's just something to keep in mind. And then finally, and this won't surprise anyone on the call, if lawyer requests are going to be prioritized or expedited under Connecticut law, making healthcare providers have to rush through otherwise required processes that support patient privacy, well, then we think the provider should be held harmless from any defects in the paperwork that a law firm or lawyer might present. And of course, that shouldn't surprise any of you. So those are sort of the four core principles that are in our head as we analyze and review, these proposals. We do think we have things we can work on together and generate some sort of positive outcome going forward. But we did want to take this opportunity to sort of articulate some of our priorities and again, express appreciation for some of the discussion that's already occurred, on these principles. So thank you, Mr. Chairman, and I'll surrender the floor at this time.
Carl, one question for you. Of your member hospitals, do you know how many do their records themselves versus how many contract with third-party providers?
Yeah, I don't have the hard numbers for you. We do talk regularly with our health information directors. Many of the hospitals, and I would say most of the hospitals, engage some form of third-party service to get those services done. But as I've always said in the 13 years I've worked here at CHA, 29 acute care hospitals, 29 different ways of doing things. And even if the hospital resides in a healthcare system, like some of the healthcare systems that have been mentioned today, that doesn't necessarily mean that they're all doing it the same way. And I think Kyle also mentioned that even within healthcare systems, just like in the judicial branch, there can be different computer systems at work which require, a degree of diligence that you might not have expected. In a perfect world, it would all be uniform. We're still a long way away from that. So I hope that helps answer your question. So unfortunately, not all of them, but most of them, Rep. Quinn.
Okay, thank you. Kyle. You're muted. You're doing your best work. You're muted.
Thank you. Thank you, Carl, for that information, and we appreciate that. I would like to acknowledge a statement made earlier by Michael D'Amico as well as Carl, and reiterate that at Datavant, we put patients' privacy first and foremost. That is what we're here to protect. We work on behalf of the medical providers to protect patient privacy in the disclosure, the proper disclosure of medical records to third-party requesters and other medical providers and payors. But I want to address one point that was brought up by Michael D'Amico and Carl, and that was about this patient right of access under HIPAA. And the fact that in my draft, I left it as the patient, and then it gives a litany of people, and then it establishes the fee, the per page fee that can be charged. And I appreciate the language that Michael submitted, which clarifies what a patient can be charged under HIPAA. The reason why I did not change that language was merely for efficiency in drafting, because many states across the country have that language that says a patient and then it lists a litany of people can request a record at a certain fee. And HIPAA actually has language within it today that preempts any state law that would allow a patient themselves to be charged more than what HIPAA permits. So that's why even in today's law at 65 cents a page, if a patient John Doe comes in and says, I'd like my record, I'm going to give this to my treating provider, we would still be bound by HIPAA, and that's what we charge. In our billing system today, we are not charging patients in Connecticut 65 cents a page. Now we're charging third parties that, but we're not charging a patient because we're following HIPAA. So that's the rationale that I used for not changing that language, was merely from an efficiency and a preemption at federal law. But I can definitely appreciate Michael's stance on, hey, let's get this right, and Carl's stance on let's not have something in our law that conflicts with HIPAA. So I just wanted to say that I agree with those statements, and if we can nail that language down, I'd be on board with it.
Yep. Kyle, how
Thank you.
many states is your group in?
All 50.
Okay. All right.
And the District of Columbia.
Okay. Rep. Conley.
I just wanted to clarify for something that Carl just mentioned, specifically in the statement that attorneys are different than people trying to get medical record. Trying to get treatment authorized. And I know we've talked a lot about the non-workers' comp statute, but the attorneys on both the injured worker side and the insurance company side are regular, and I want to make sure our record's crystal clear at this, are regularly requesting medical records for the purpose of authorization of treatment. And I don't want that to get confused when we're talking about the non-workers' comp statutes. So there will be some sort of a need to figure out, because I understand under the current systems that if attorney requests are not being prioritized in the same way as insurance requests, the attorneys representing the insurance company's requests are not being prioritized in the same way as insurance requests, and neither are the attorneys representing the claimants for the purpose of the workers' comp medical authorization. And I know that the conversation hopefully we'll have next time in depth as to how to change that statute, but I just want to make sure the record's clear that many attorney requests in the workers' comp realm are solely for the purpose of getting that patient medical treatment authorized, which is the doctor's request, which is the facility's request, which is the whole system's request on how can we speed that up.
Thank you. Mike, did you have another question?
I think Kyle addressed it by acknowledging that there is a conflict between the proposal that he submitted and HIPAA, and it just doesn't make any sense to me that we would be behind a state statute that clearly conflicts with federal law. So I'm sure we can address that as we move forward. And I tried to address that in the proposal that I submitted, which I'm happy to talk about at your pleasure.
Okay. All right. Thank you. Anyone else on either of the proposals at this point? Any other comments go ahead, Kyle.
I do want to address, I believe it was Michael D'Amico who submitted the other proposal modified from their first one. And my take on Michael's two proposals. The first one was really kind of a reiteration of the legislation that was filed this past session. So the fact that now there's an acknowledgement that there should be a per page fee for an electronic record and I believe he proposed 35 cents a page in this latest draft. Michael, please interject and correct me if I'm wrong on any of this, but I believe it was 35 cents a page. I want to say I appreciate the fact that he's acknowledging a per page fee for an electronic record. And then the fact that there was a search and handling fee that was proposed of $20. I appreciate that, but were limitations on it, and that is that it would only apply if there was a record more than 100 pages. And then there was a cap of $20, which, I mean, if we're comparing other states, which we've done in numerous circumstances in this call, the $20 cap on an electronic record would be the lowest in the country. And we've already acknowledged on this call with this group that the cost of labor and the cost of living and the cost of goods in general in Connecticut is much higher than it is in some of these other states. I know that Utah was one that we brought up before, where they have a $33 base fee or search and handling fee, and then they do have a lower per page fee. And so they put an emphasis on that search and handling fee and not as much emphasis on the per page fee. And then they also have a cap on the electronic. They also have a CPI adjuster though. And I'd like to acknowledge that if we don't want this to fall behind and need to be reviewed every so often, we could even consider a CPI adjuster in the law that's applied, say, every 3 years or something to that effect. So it's not an annual increase. And keep in mind that a CPI adjuster is not always an increase. There can be times when it's decreased as well.
Okay. Mike, did you want to respond to that before I call on Rep. O'Day?
I think I would defer to Representative O'Day. I did want to have a chance to talk about the proposal that I submitted just quickly, and I could at that time maybe address some of the comments that Kyle's made.
Okay, then we'll go to Rep. O'Day and then back to you, Mike.
Thank you very much, Representative Quinn and everybody. Real quick, Mike, I don't know if you and Rick have kind of picked this. Is there a state that you believe we should mirror? And I did not compare your proposal to any other states. So with legislation. So I'm wondering, so one, is there a state that you would like us to see mirror? And to Kyle, what state he would like to see us mirror? And I do agree, look, we're moving more, and I'll defer to my good colleagues on the other side of the aisle, but you know, as a legislature, we've been adding the CPI index so we don't have to revisit these all the time on a number of bills in the past. So I'm amenable to the CPI index adjuster being put in there so they don't have to keep coming back to this. Again, I'm less concerned about the $15, $20, $30 fees than I am about the $10,000 bills. So to the extent we can kind of all coalesce around what another state has done to treat the electronic differently, the third party request differently, and to have a cap, I would like to see both competing sides say, hey, this state does it well or that state does it well. Let's take a look at those and tweak them to what's best for Connecticut. So just wondering if you all can kind of respond to what states you like.
Go ahead, Mike.
So I can respond by saying that I haven't had the opportunity to read all of the many record bills and statutes that are out there in order to say which ones we would propose or not propose. I thought that it was a better and more efficient use of time to try to look at the existing statute that we have and then try to make some modifications accordingly. And so the extent of my dive into the other statutes really has been to get some sense of how they were addressing electronic records, how they were addressing search fees or not, per page fees for hard copy or not, per page fees for electronic copies or not, caps on electronic records or not, timing of requests or not, to make sure that all of the issues that other states have addressed, that we've done our job in addressing as well, so that we eliminate any issues that we may have missed. I always feel like multiple heads are better than one, and it certainly helps to see what others have done around the country. So I can't say that there's one in particular that I would propose, although I have done my darndest to try to make sure I'm aware of what other states have done so that we've at least addressed the issues, or we've had the opportunity to discuss them here on this committee, so that we make sure that when we do put out a proposal, it's all encompassing, well thought out, well informed, and a good product that we can all live with and be proud of.
Okay, I'll go to Rick and then Kyle.
I'll just be very quick. We've requested from our National Trial Association an analysis of every state. And that analysis, and I thought Mike was going to provide it to you, certainly doesn't support what Kyle just said. There are 14 states that have no fees. There are numerous states that have a $5 fee, $10 fee. So I'm in complete disagreement with what Kyle said. And the other statement I want to make just very briefly, there is no concern with having a separate section, as Mike proposed, for attorneys getting records and third party getting records and individual getting records, and is not in conflict with HIPAA.
Okay,
Short and sweet.
thank you. Kyle, go ahead.
Thank you, Representative Quinn. To address Representative O'Day's question, I don't know that there is one particular state that I would gravitate towards. I think that Connecticut should, and what I would like to see this work group do, is evaluate each of the states out there and come up with what we believe is best for Connecticut. I think that it's very easy to fall into a trap of, everyone, I think, would assume on the call that me being in the industry, I would say, oh, let's go with the highest rated state. And then everyone on the trial attorney side is going to say, oh, let's go with the lowest rated. And I think that the reality is what's best for everyone is somewhere in the middle. Right. And so I would say let's take an approach, a reasonable approach of let's institute something to compensate us for that search and handling and validation upfront on every request. And maybe it's not $25. To Representative Quinn's point earlier, I mean, maybe it's something less than that. But I think that work is valid on every request that we do. And then let's look at the per page fees and acknowledge that we don't have the material cost when we have an electronic delivery. So should it be less than the per page for paper? Probably it should. Now let's look at the caps. We want to incentivize people to go to electronic delivery. It's faster, it's safer, it's more secure. So let's incentivize people to go to electronic, and let's do that with the caps so that we don't have the runaway invoices that I heard you just address concern with moments ago. I want to make those reasonable, and in that way, if we don't have a cap on paper, hopefully people will say, look, I want to go with the electronic, so I know that I'm never going to pay more than whatever dollars. To the point before about the $300 being a bit high, I will admit the highest in the country right now, the highest cap is South Carolina, which is $248.23. Now, that fee was established, or that cap was established in the legislature, I believe, in 2014, and was adjusted for CPI over the years because they have an automatic CPI adjuster every year annually. So that's why it's at $248 now. I believe the original amount was $200. So it's gone up $48 in, what is that, 9 years? So that'll give you an idea of the environment that we're living in today. Is to say in 2014, and by the way, 2014, I think, is the first year that I worked with the Connecticut legislature on a medical record fee bill. Nothing passed, but I believe that was the first year. It might have been 2013 now that I think about it, but it was in that range right around the same time as South Carolina.
Anybody else? Go ahead, Mike.
So is now an appropriate time for me just to run through the revised proposal?
Yes.
Okay. Bear with me while I take a look. I'm looking at my red line version of it. And by the way, this is only referring to 20-7C. I didn't take the time to make consistent changes with the 19A one, but certainly can do that. So the first thing I did was suggest that we have a form authorization. And I leave that to collective minds to make sure if we're going to have a form authorization that we all make sure that we have a form that's consistent with HIPAA, solves the hospital association's concerns, all of our concerns about privacy, and we make sure that we get the form right. I then, in consideration of Representative Conley's concerns and Jennifer's concerns, eliminated color copy as being applicable to all requests, and instead made it an option, as you'll see later on. Then what I did was I separated out the charges that that would be applicable to a patient's attorney or other authorized representatives request. And I did that with the express purpose of, one, complying with federal law currently, and also taking into consideration the concerns expressed by Kyle and Liz about a mechanism by which we may be able to allow for perhaps a search fee applicable at times, a per page fee for electronic records that might be applicable at times. And we couldn't do that if we didn't separate out the lawyer's requests and the patient requests. So I did this with an eye towards, is there a way that we can come to some collective agreement on a proposal? So the way it reads initially is that a patient's attorney or other authorized representative cannot be charged more than 65 cents a page for a black and white paper copy, or 75 cents per page for a color paper copy if it's requested to be produced in color. And that includes any research fees, handling fees, and only excludes postage. So that would be in addition. And I recognize, as I mentioned before, Kyle's discussion about the time that's elapsed since this statute was originally passed and today, and so shouldn't that per page rate be higher? But when I did look at the per page rate that's charged by other commercial copying companies, for instance, and I accept the fact that their labor is not as intensive perhaps as what Kyle has addressed, but for instance, Staples charges 22 cents a page for black and white, and I think they charge 66 cents a page for color, and I would imagine other commercial copying places are in line with that. And I also took the time to average out what all the other states charge for hard copies when they do it in a per page way. And I will say it was an imperfect attempt, in part because of the tiered nature of some of the states' provisions about per page rates for hard copies. But I did my best, and when I averaged out, it was all below 65 cents a page. I think one of them came out to 64 and the other one I think came out to 51. I think what I did, Kyle, is I took your list, which had I think you represented as the more recent bills that were passed about records requests. On the one hand, I averaged those, and then I went through the whole other exercise by taking our list, which was every single state in the country that had records requests, and I looked at the averages from both your list and the list that was complete and current, meaning as of today. And those averages didn't suggest to me that it was appropriate or necessary to modify the 65 cents a page. And then what I did was I had a provision in there for 35 cents a page for an electronic copy, but capped it at $20. And the only reason I put a per page fee in there for an electronic copy was because it allowed us to provide a cap. And as I'll talk about in a moment, it also kind of dovetails in with when a search fee might be appropriate. And this is in response to Representative Conley's thoughts. And we've talked to a number of folks that have expressed concerns about, you get a 2-page record and why should it cost you $25? And so with that concern in mind, a per page fee was something I thought was reasonable for an electronic copy, capped at $20. So if you have a 2-page record, then you're going to get charged 70 cents if it's electronic. If it's a 1,000-page record, and we'll talk about that as I go a little bit further, then you would potentially get charged. I didn't do the math in my head, but no more than $20 plus a search fee. And so let me comment about the search fee just for a moment. Connecticut public policy doesn't seem to like search fees because it's never been allowable under Connecticut law at all. And HIPAA doesn't like it either, at least for patient use requests, because they prohibit it. So I recognize that, having a provision in here about a search fee is kind of contrary to what Connecticut has felt all along. But in an attempt to try to meet some of the concerns that Kyle raised and perhaps come up with a collective agreement, I thought that it might be appropriate to have a search fee only with certain requests. And so I did allow for a search fee if the request was in excess of 100 pages and allowed for a $20 search fee. And so why did I come up with a $20 search fee? Well, again, what I did was I went through and I averaged these search fees across the country, both on Kyle's list and then the list of every state in the country. And I think one of the averages came out to $22. I think the other one came out to $24. Instead of saying $23, I said $20. I probably could have said 24 or 25. I thought that $20 was reasonable given the fact that Connecticut traditionally just hasn't liked search fees at all. And so I thought it might be reasonable in a blending of the different perspectives here to have some type of a search fee. I also tried to address Jennifer's concerns about the provision of a color copy that is electronic. I have to say I don't fully understand it, and I don't know if Carl has further information about it. But Jennifer raised some concern that some electronic health systems don't have the ability to print out something in color, or maybe not print it out, but to copy something in color. I wasn't sure I really understood that, but I did put a provision in here addressing that by saying that if a patient's health records is maintained in an electronic format, and it can in fact produce a color electronic copy, then if it's requested in color, that it should be produced in color. I didn't allow for a higher per page rate for an electronic copy for color because there's no toner involved. It didn't seem to me that it was appropriate to do that. And so I only increased the per page rate for a hard copy requested in color. And incidentally, to Kyle's point, and again, this was in the spirit of compromise and negotiation, I didn't cap the per page fees for hard copies. So whatever the hard copy per page fee is, it is. And I did that because most are electronic these days, and it does encourage requesting it in an electronic format. I also tried to address Representative Conley's concerns about an expedited copy, that there are other reasons why a copy may need to be expedited. It may not just be related to a statute of limitations. And I appreciate Carl's comments today where he said that an expedited copy is necessitated for healthcare decision making, and that is certainly an important reason to expedite a copy. I don't think anyone would ever question that. And I have to express ignorance. I'm not aware of 23-97. So I would love to see that. And I don't know if that only applies to healthcare decision making or if it applies in other circumstances. But to Representative Conley's points, I tried to add a phrase in here that said, or other good cause necessitating an expedited copy, meaning not just because of the statute of limitations, but other good cause. And I realize that's somewhat amorphous, and we do want to avoid the situation where every copy is an expedited copy, because I agree that's a problem, and we certainly don't want to encourage that. So we do want to reserve that for those circumstances where it's appropriate, and we can, I think have further discussion and make sure that we get that one right. And then I added a whole new subsection related to patient requests or a representative that has authority to make healthcare decisions, because HIPAA treats those folks differently under federal law right now. And it really wasn't necessary, I thought, to address what could be charged a patient, because as Kyle stated, even if the state statute was passed, it was in conflict with federal law. They're only going to get charged what federal law provides anyway. So why do we need to monkey with that? Federal law does a really good job of dealing with how much a patient can be charged if it's what they refer to sometimes as a personal use request. And so I simply said that the fees allowable under Connecticut state law in my proposal are consistent with those allowable. And I cited the specific Code of Federal Regulation section. The only thing that I did do, because the federal law doesn't talk about a per page fee for a hard copy. And what I didn't want to do is have some vagueness about what can be charged to patient if it's a hard copy, and so I wanted to make it pretty clear that if it's a hard copy, then the fee that can be charged to the patient is 65 cents a page. That is not in conflict with federal law, and it eliminates a potential problem. And then the sections that the way the statute is currently worded right now, there's some phrases and sentences in there that really should be like in a separate section, because when you read through it, you kind of start scratching your head and you said, geez, why is that there? And so I didn't change them at all language wise. I just moved them into their own subsection. So when you read through this, it actually made more sense. And then there was a concern that's been expressed, and it has been a problem. Rick's commented quite a bit about it, but we all have had this experience that if it isn't produced within 30 days, then what do we do to put a provision in here that's going to encourage compliance within 30 days? And so I put a provision in here that says that if it's not produced within 30 days, that the fees that are allowable under my proposal are reduced by 50%. I think that's consistent with what Kyle has suggested. But if it's not produced within 45 days, then it's free. Then it's free of charge. Then there isn't any charge that can be made. And so I did what I spent a good amount of time on it. I did what I could to consider the varying perspectives and the issues that have been raised. I tried to only monkey with the statute where I felt that it was necessary. And I thought I tried my darndest to give credence to the different perspectives and kind of give us a draft that I thought that we could have some good further reasoned and informed discussion about.
Okay. Thank you, Mike. Any other comments from anyone at this point?
What I would, with your permission, I would like to send everyone a copy of what every state has done that was formulated by the National Association. And in addition, I would like to submit an example of the delays just that I picked out for 2 cases of essentially 3 months with 20 phone calls to get record.
Yeah, that's fine. Why don't you send them to me and Nate, and we'll get them out to the group. That's fine. Thank you, Rick. All right, anybody else? All right, the next and I'm just looking for consensus on this because I know neither is going to be good. The next Tuesday would be the 26th, which is the day after Christmas. The following Tuesday is January 2nd, which is the day after New Year's. I guess pick your poison. Do we want to keep, I know that the week between Christmas and New Year's is generally the most difficult with people traveling. So if we did January 2nd, does that work better for everyone?
Okay by me.
Yes.
Okay.
Yeah.
All right, then that's what we'll do is we'll pick January 2nd at 10 o'clock as our next meeting, and we'll get things out. And Kyle, if your group wants to issue a revised version of yours, I mean, by all means, do that and get it to me and Nate, and we'll get it out to the group as soon as possible. Or if you're content with it as it is, then, don't feel an obligation to change it. Okay.
Thank you, Representative Quinn. Can I ask a question as far as a formality
Sure.
of this work group? Is the expectation that, and I ask because I don't know, is the expectation that we will have a draft presented that we as individual members like vote up or down on, or is the expectation that there is a certain stakeholder here that will put together a draft based on all the testimony and documents and revisions and everything we've heard? Like, what is, I guess what I'm asking is, how do we get to an end result and recommendation?
I think that the expectation would be that we would eventually vote on something, and that is what I would hand off to the legislature for consideration during the next session. How exactly we get to that point, I don't know that we're quite there yet, but we seem to have some consensus forming on some aspects of it. And I do recognize that there are other aspects of it that we might never get to a consensus on. Yeah, I mean, that's my expectation, is that by the end of this, we will have something that everybody can vote up or down on. And then assuming there are more up votes than down votes, that's what we would pass on to the legislature. And of course, it would go through the whole process as well. But that's my expectation. And does that completely answer your question?
About 90%.
Okay.
And I guess the remaining 10% is, where does the actual document we would vote up and down on, who does that come from, I guess? And I guess would that come from my without having discussed this with everyone, expectation is I thought maybe you and Representative Conley, as the co-chairs of this work group, would probably say, here's what we think after talking with everyone. Am I right or wrong in that?
I think that that's a correct conclusion, that it would be generated by the two of us, taking into account as many areas where we have consensus, and then go from there. So we would put the onus on ourselves to do that.
Thank you for that information. I appreciate it.
Okay. All right, if there's nothing else, again, our next meeting will be January 2nd at 10 o'clock here on Zoom. And if I could have a motion to adjourn.
So moved.
Second. Thank you, Rep. Conley. All in favor?
Aye.
Aye.
All right. Thank you very much. And again, everyone have a safe holiday season, and we'll see you back here on January 2nd, 2024.
You as well. Stay well.